Just as William Alsup leaned back in his chair, a sly grin spreading across his face, Congresswoman Jasmine Crockett stepped toward the witness stand in the crowded federal courthouse. Only moments earlier, he had brushed aside her legal argument with a casual wave of his hand, calling it the sort of amateur reasoning I'd expect from a first-year law student. The audience gasped at the unusually sharp reprimand of the black congresswoman and former public defender. Alsup's grin said it all. He believed he held the upper hand, that decades on the bench made him untouchable. But what happened in the next few minutes left the entire courtroom stunned, and may forever reshape how judicial overreach is viewed in America. Crockett, gripping her legal pad tightly, eyes locked on the 78-year-old judge, refused to back down. This wasn't just another hearing. It was about to become a masterclass in standing up to judicial arrogance. Before diving into this incredible showdown, make sure to hit the like button and subscribe so you don't miss our latest political clashes and moments of justice being served. That morning, the federal courthouse in Washington, D.C. buzzed with anticipation. The ornate chamber, with its towering ceilings and dark wood panels, was packed to capacity. Reporters filled the back rows, pens poised over notepads. This wasn't just any hearing. It was a pivotal case on voting rights. An issue dividing the nation. Justice William Alsup, appointed to the bench by President Clinton in 1999, had long been known as a no-nonsense judge. At 78, his silver hair and ever-stern expression gave him an aura of authority few dared to challenge. Having presided over landmark cases involving Google, Uber, and major constitutional disputes, Alsup was respected for his sharp intellect and feared for his sharper tongue. Critics even dubbed him the smirking judge, notorious for flashing a knowing grin whenever he thought lawyers were stretching their arguments. In recent years, though, Alsup had become increasingly dismissive of progressive cases, especially those on voting rights. Legal observers noted his impatience with younger attorneys, particularly women of color. His rulings had tilted noticeably rightward, alarming many who once viewed him as a balanced jurist. Standing before him that day was Congresswoman Jasmine Crockett of Texas's 30th District. At 42, Crockett was new to Congress, but not new to the courtroom. Before politics, she built a formidable reputation as a civil rights attorney and public defender, handling more than 100 trials. She earned the nickname the Giant Slayer for her ability to dismantle powerful opponents with sharp legal reasoning and commanding presence. Crockett wasn't in court as a mere observer. She had filed an amicus brief in the voting rights case and was granted time to speak. As a member of the House Judiciary Committee and the Congressional Black Caucus, she had a vested interest in a case that could impact millions of Americans, especially communities of color. The stakes couldn't have been higher. This ruling would decide whether new voting restrictions in several states would stand or fall. Civil rights groups had already called it the most consequential voting rights case in a generation. Tensions were especially high after what unfolded the day before. In preliminary hearings, Alsup repeatedly interrupted female attorneys while giving male attorneys room to argue. When Crockett's team presented statistics on voter disenfranchisement, Alsup visibly rolled his eyes and muttered something sounding like typical exaggeration, caught by front-row reporters. Rumors spread that he had privately remarked a freshman congresswoman didn't deserve special time to address his court. He only granted Crockett her slot after heavy pressure from higher courts. So when Crockett approached the podium that morning, the room held its breath. Alsup didn't even look up at first, a gesture of disrespect noticed by all. When he finally raised his eyes, it was with his trademark smirk, the same one that had rattled countless lawyers before. But Jasmine Crockett wasn't like those attorneys. She had faced hostile judges in Texas, battled systemic racism in the courts, and now, as both a congresswoman and constitutional lawyer, she carried not only her own authority but the voice of her constituents. "Your Honor," she began, her voice steady and clear. "Before I address the legal merits of this case, I must speak to your characterization of our arguments yesterday." Alsup's smirk widened as he leaned forward. "Congresswoman, this is my courtroom. I've been interpreting constitutional law since before you even passed the bar. If you have real arguments, get to them. Without the lecture." The courtroom fell silent. The battle lines were drawn. "With all due respect, Your Honor," Crockett replied, her tone sharpening, "I passed the bar after studying the same Constitution you did. That document doesn't change depending on how long one has been interpreting it." A ripple of murmurs spread through the audience. Alsup's grin faltered for a moment before he regained composure. "Congresswoman Crockett, may I remind you, in this courtroom, I am the final authority on constitutional interpretation. Your political office doesn't grant you legal expertise." Crockett stood firm, her eyes blazing with resolve. "I'm not speaking today as a politician, Your Honor. I'm speaking as an attorney, one who has represented precisely the voters who will be disenfranchised if these restrictions stand." Alsup tapped his gavel lightly. "The impact of these measures is exactly what this court must decide. Congresswoman, your assumption of disenfranchisement presumes the very conclusion we're here to determine." The tension only mounted as Crockett opened a folder on the podium. "Then let's examine the evidence, Your Honor. May I present the statistical analysis your court cut short yesterday?" "You may proceed," Alsup said with a dismissive wave. "Though, let the record show, statistics can be twisted to argue almost anything." The remark drew visible reactions from civil rights attorneys in the room. Crockett inhaled deeply, then pressed on. Methodically, she presented data showing how the restrictions disproportionately harmed minority communities, rural voters, and the elderly. As she laid out the evidence, Alsup's interruptions grew sharper. "These numbers ignore alternative voting methods," he interjected. "Actually, Your Honor," Crockett countered smoothly, "if you'll turn to page 17 of our brief, we've provided a full analysis of all voting methods affected by these laws." Alsup frowned, flipping irritably through the papers, clearly not expecting her to be so prepared. "And what about the state's interest in preventing fraud?" he challenged. Crockett was ready. "I was just getting to that, Your Honor. If I may direct the court to Exhibit C, it documents every confirmed instance of voter fraud in these states over the past 20 years. She revealed a chart. Fewer than 30 cases out of millions of ballots cast. These rare cases hardly justify restrictions that could block hundreds of thousands of legitimate voters, she concluded. Alsup shifted uneasily in his chair. "The potential for fraud is what concerns legislators, Congresswoman. They have a duty to be proactive." "A duty," Crockett replied firmly. "That must always be weighed against the constitutional right to vote." "And speaking of duties, Your Honor, I believe the judiciary has a duty to scrutinize laws that may violate constitutional rights, not simply defer to legislative bodies." The judge's face tightened. "I am well aware of judicial review, Congresswoman. I've been practicing it for decades." "Then you're also aware, Your Honor, of the Supreme Court's ruling in Harper v. Virginia Board of Elections, which held that wealth or fee-paying has no connection to voting qualifications." Alsup leaned forward. "Harper was about poll taxes, Congresswoman. These measures are verification procedures." "Procedures," Crockett countered sharply, "that function as modern-day poll taxes when they require voters to purchase documentation or travel long distances at personal cost. The mechanism may differ, but the effect is the same." Reporters in the gallery scribbled furiously. This wasn't just a hearing anymore. It was becoming a defining moment, a congresswoman openly challenging a federal judge, not only on the legal merits, but on his very approach to judicial review. Sensing the momentum shift, Alsup tried to cut her down. "Congresswoman Crockett, while your passion is admirable, this court requires legal arguments, not emotional appeals about voting rights." The dismissal of voting rights as emotional drew visible reactions throughout the room. Crockett stood still for a beat, her expression unreadable. Then, unexpectedly, she smiled. "Your Honor, I find it interesting that when male attorneys argue about the Second Amendment or corporate speech, it's considered scholarly. But when a black woman presents constitutional arguments about voting rights, the very foundation of democracy, it's dismissed as emotional." Gasps rippled through the chamber. No one had ever confronted Judge Alsup's bias so directly. His smirk vanished, replaced by a glare. "I'd advise you to be very careful about impugning this court's impartiality, Congresswoman. I'm not impugning anything, Your Honor. I'm pointing out a pattern, one relevant to these proceedings. And since you've raised the issue of argument styles, allow me to present something else." She nodded to her assistant, who handed her a document. "This is a transcript from the Shelby County case where you stated, 'Times have changed, and the extraordinary measures once necessary may no longer be needed.' Yet the data we've presented today proves voter suppression hasn't disappeared. It's evolved," Alsup bristled. "You're taking my words out of context." "Then please provide the context, Your Honor," Crockett shot back. "Because to millions of voters, it appears the judiciary is retreating from its duty to protect voting rights precisely as new forms of suppression emerge." The judge's gavel cracked down sharply. "This court will recess for 15 minutes. He stood abruptly and left the bench. The courtroom erupted into whispers. Legal experts exchanged stunned looks. Never before had the formidable Alsup been forced into retreat mid-hearing. Journalists typed furiously, already knowing this clash would dominate headlines. Crockett, however, remained composed at the podium. Her team approached with quiet congratulations, but she only shook her head. This wasn't over. The true confrontation was still ahead. When Alsup returned 15 minutes later, his demeanor had hardened. The smirk was gone, replaced with cold determination. "Congresswoman Crockett," he began, voice tight, "before the recess you made rather bold claims of judicial bias. Let me remind you, respect for this court is not optional." Crockett nodded calmly. "I have the utmost respect for this court, Your Honor. That's why I believe these issues must be addressed openly." "Then stick to the legal merits," Alsup barked. "Very well," Crockett replied, flipping a page in her notes. "Let's discuss Crawford v. Marion County Election Board, where the Supreme Court upheld Indiana's voter ID law." Allup's expression shifted. "Finally, precedent. As Your Honor knows," Crockett continued, "that ruling depended on the state showing both a legitimate interest and that the burden on voters was not severe. But," she paused, locking eyes with him, "the court also emphasized that ruling was tied to that specific factual record. And here, the facts are very different." She laid out how the new restrictions were far harsher, targeting specific demographics with precision. For each objection Alsup raised, she had a clear, factual rebuttal. The balance of power in the room was shifting. Then came the breaking point. "Congresswoman," Alsup said, voice edged with frustration. "Perhaps in the political arena these emotional appeals about voter suppression earn applause. But this is a court of law, not a campaign rally. Stick to legal standards, not convenient narratives." The phrase "convenient narratives" landed like an explosion. Attorneys stiffened. Reporters stopped mid-sentence. Crockett froze, visibly stunned, then slowly straightened. "Your Honor," she said, her voice calm yet cutting, "did you just characterize the systematic exclusion of citizens from their constitutional right to vote as a convenient narrative?" Alsup shifted uncomfortably. "I was referring to the description of these verification procedures." "With respect, Your Honor," Crockett interrupted, "you dismissed disenfranchisement itself as emotional and convenient. That reveals a prejudgment about this case and raises serious questions about whether voting rights advocates can truly receive fair consideration in this court." Gasps echoed through the chamber. No one spoke to a federal judge like this. Allup's face flushed red. "Congresswoman Crockett, you are dangerously close to contempt of court." The tension peaked. The entire room held its breath. Crockett reached calmly into her briefcase and withdrew a small, worn book. "Your Honor, I carry this with me everywhere," she said, holding it up. "The Constitution." She opened to the 15th Amendment and read aloud. "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude." Then, placing it firmly on the podium, she declared, "The protection of this right isn't a convenient narrative. It's the explicit text of our Constitution. If defending that text puts me in contempt of this court, then I am prepared to face those consequences." The courtroom fell into stunned silence. Legal experts present would later describe this as one of the most dramatic confrontations ever witnessed in a federal court. Crockett stood firm, unwavering in her position. Judge Alsup, realizing he had backed himself into a corner, hesitated. His threat of contempt now hung awkwardly in the air. Following through would only validate Crockett's concerns about judicial fairness. "Let's proceed with your legal arguments, Congresswoman," he finally said, his voice noticeably less confident than before. The first round had gone to Crockett, but the battle was far from over. What began as a routine hearing had now transformed into a historic confrontation. Judge Alsup, usually in complete command, found himself on the defensive. As the afternoon session resumed, he attempted to regain control. "Congresswoman, you've made provocative claims about intent. But as you know, discriminatory intent must be proven, not asserted." Crockett nodded calmly, as if expecting this. "I'm glad you raised that, Your Honor." She gestured, and her assistant approached with a sealed folder. "What I'm about to present was obtained through discovery in a parallel state case. These documents were under seal until this morning." Alsup frowned, caught off guard. "This court hasn't reviewed these materials." "That's correct, Your Honor. They became available at 9:15 a.m. Copies have been prepared for the court and opposing counsel." As the documents were handed out, Crockett continued, "These are internal emails and planning documents from the legislators who drafted the restrictions at issue." The courtroom fell silent. Within moments, the state's lawyers were huddled, whispering urgently, "Objection!" Their lead attorney rose. "These weren't included in the amicus brief." "Because they weren't available then," Crockett countered smoothly. "But they are directly relevant to the intent Your Honor just raised." Judge Alsup scanned the pages, his expression darkening. "What exactly are you alleging these show?" Crockett's voice was steady. "They reveal legislators explicitly targeting what they called demographic challenges to their power. They studied voting patterns by race, age, and income. They identified methods used predominantly by minority communities and then tailored restrictions to block those methods." She highlighted specific passages. One email read, "If we can reduce turnout in these 5 urban districts by just 3%, we maintain control indefinitely." Another referred to historically black colleges as opposition voter factories and detailed plans to invalidate student IDs for voting while protecting gun licenses. The impact was immediate. Reporters scribbled furiously. Civil rights attorneys exchanged looks of vindication. The state's lawyers looked shaken. Crockett then revealed the most damning piece. An email from the Speaker of the House instructing, "Frame everything around election security. Never mention demographics in writing. Remember, we need neutral justifications for the courts." The room erupted in whispers. This wasn't just intent. It was evidence of deliberate deception. Judge Alsup sat in silence, visibly troubled. "Congresswoman Crockett, the court appreciates these materials. They will require careful review." But Crockett pressed further. "Your Honor, earlier today, you dismissed concerns about disenfranchisement as emotional appeals and convenient narratives. These documents prove why such skepticism is dangerous. Legislators counted on it. They believed if they offered a neutral pretext, courts would look no deeper. They were banking on judges who would dismiss discrimination as a narrative. The parallel to Alsup's own words was unmistakable. The judge who began the day with smirks now faced the shadow of complicity. The state's attorneys scrambled to argue context, that these were isolated views. But when they claimed demographic challenges could mean any group, Crockett pointed directly to another email naming African American turnout as the problem. By late afternoon, it was clear the case had shifted. What began as a battle over technical restrictions had become an exposé of intentional discrimination, and the judiciary's role in enabling it.